And we right back with another update on the Big U case. Now, we've gone over in the last couple of weeks Big U filing a motion to suppress evidence and a couple of other motions, and how he wanted these motions to be heard by a different judge than the one that he had assigned to him, because that was the same judge that originally signed the warrants that he's trying to have suppressed. So, the judge recused himself from that, and like I said, that was a victory. He got what he was looking for. Now that that judge has been removed, Big U finds himself in a situation where he has to, figure out how he is going to get everything rescheduled, because of course that hearing was scheduled to come up I believe like July 9th or something along those lines. We're going to get a chance to look at the paperwork actually in this video. But now he has to get everything rescheduled, which, they got to be careful with that, because they don't want things to get pushed so far back that it affects the trial date. And they also don't want to rush things because, as we talked about earlier, the defense believes that the prosecution is stalling when it comes to certain things, just so they can have, the opportunity to present this case without certain information being brought up. Specifically, the defense believes that the prosecution is stalling when it comes to actually sentencing the witnesses, Big Dale, Molly Ma, because they don't want Big U to have the opportunity to bring up on cross-examination that these guys were given deals in order to cooperate, stuff like that. Now let's get to the paperwork. What you are looking at on your screen right now is the official court document. This is defendant Eugene Henley's ex parte application to set briefing and hearing schedule for reassigned wiretap suppression. And it says that, they want to reset a briefing and hearing schedule. A status conference is the necessary first step. The recusal and reassignment have left both the schedule and structure of the evidentiary hearing for the court to set. It was supposed to go down sometime this month in July. Mr. Henley proposes that the court set the status conference for July 9th, 2026, a supplemental briefing deadline of August 6th, and a hearing on September 24th or October 8th, subject to the court's discretion at the conference. The government takes no position on the briefing and hearing dates and defers to the court. So basically, it's saying that the government is not challenging these dates that they have set up, and they are basically saying, whatever the court decides, that's what we are going to run with. Relevant background: on May 18, 2026, a hearing schedule was set for all pretrial motions, and this one was scheduled for July 15th. Since then, that judge has recused themselves. Following a June 10th hearing, the court said July 3rd is the deadline for supplemental briefing. On June 22nd, the judge recused himself from the wiretap suppression motions. The court explained that because it had reviewed, considered, and authorized the pre-indictment wire intercepts that are the subject of the pending motions to suppress, it recused out of an abundance of caution, finding that a reasonable person with knowledge of all the facts would conclude that this court's impartiality might reasonably be questioned. On June 27th, defense counsel proposed the schedule set out above. On June 29th, the government responded that it takes no position on the briefing and hearing dates and will defer to the court. Now, they present their argument for why a status conference should be held. And it says that a status conference is the efficient way to reset these motions. And July 9th, 2026 is the first date that the parties can hold one. The court is entering the case after a year of litigation. Accordingly, it is important that the court have an opportunity to set its own schedule and the parameters of the evidentiary hearing it will conduct. So they want to get all of the rules and guidelines. They want to get the motions and all of that stuff. Not the motions, but the briefing, the paper arguments that they're going to present. They want to get all of that stuff scheduled and set so they can continue moving forward with this case. These are things that they will want settled before briefing, like which witnesses will be called, the order and time for the estimated testimony, whether the parties should exchange witness declarations in advance to narrow the issues and shorten the testimony the court must hear. Defining these at a conference lets the court receive supplemental briefing and any supporting declarations built to its procedure. The existing dates do not stand in the way. The July 3rd supplemental briefing date and July 15th hearing date were tied to a schedule set by the recused judge. Ex parte relief is the proper vehicle. The July 3rd and July 15th dates are imminent, and a regularly noticed motion could not be heard before them. The need to reset arose through no party's fault from the recusal and reassignment of the judge. This is something that I want to touch on because I'm pretty sure that this is going to get granted because the government isn't taking any position contrary to it. But it says, this is the declaration of the attorney, and he says, I am an attorney duly licensed to practice in the state of California. I have been court appointed to represent Eugene Henley Jr. in this matter. A lot of these creep stalker bloggers, man, they focusing on that part. And this is what I mean when I say that these dudes are obsessed. They like to say that I'm obsessed with exposing snitches or rats, and that's not really the case. It's just that I noticed that these guys are master deflectors and they love to bring up stuff that really has no relevance. Now, I seen a goofy, I ain't even gonna say his name on here, but I seen a goofy who was literally on here saying, oh man, everybody talking about how much they love Big U and he a real dude and he a solid dude, and he ain't even got a paid attorney, man. You letting him go in with a court-appointed attorney. Well, this is the thing. Big U is being accused of extortion. Big U is being accused of several crimes that would almost subject anybody who were to assist him to an investigation. This is where I look at some of these older dudes and I realize how messed up the game is right now. Because, nigga, why are you crying about having a lawyer? This is what I be saying about, this Big U ain't came out and said, hey man, these niggas ain't got me no attorney, or he ain't did that. You know why? Because it's his bed. He laying in it, however it come. But you got weirdo creep niggas like the guy I'm talking about. I'm sure y'all know who. That always mention, oh, well, why didn't nobody see that stuff ain't real, man? It's nobody. Listen, bro, when you go to jail, and I got this from Goodfellas, so y'all gonna know what I'm talking about. Remember when Henry Hill had Karen bring up the bread and stuff to the joint, and she was like, have her sneak this shit in for you, and I went by Paulie's and he doesn't give me any money. And he told her, man, look, fuck Paulie and them. When I come to jail, it's just us. It's just me and you. We got to get it how we live. That's it, bro. You did your crime. You went to jail. Niggas be trying to, oh, man, I did this for the hood, for the homies. And no, you didn't, bro. You did that for your own personal gain. You did that for your own personal gain. You didn't hit that lick and then kick some up top. Kick a percentage up to the boss, because let you tell it, you niggas ain't had no bosses out there. Y'all was just running rampant, so it ain't like it went like that. A lot of dudes, and it ain't just this goofy. It's a lot of these niggas go to jail and they catch a case. You catch a case selling dope. You got a dude who would catch a case selling dope, right? And then he get booked. And surprisingly, but not surprisingly, he got caught selling dope, and now he don't got money for a lawyer at the same time. So now well, man, these niggas ain't gonna give me no lawyer, and I'm keeping it real. I'm keeping it solid. I ain't telling on nobody. And now that's his excuse to tell on people. That's not how this shit go, man. It's too much crying and shit going on. And you can, even when these dudes, like, you trying to put Big U down, you trying to put anybody who may consider themselves a friend of his or an associate or whatever, you trying to put them down, but you really just exposing your true nature, bro. You exposing that you the type of nigga that get out here and break the law and be broke don't have no money put aside for yourself to pay for no lawyer, then you want to cry about other niggas not getting you a lawyer just so you can have an excuse to tell on people. That's how, like, I see this shit all the time. It's the same setup. And I'm starting to see that this shit come from these older niggas. These older niggas who was already snitches and rats, you know, way before a lot of these shorties came along. And now they trying to impress upon these shorties, yeah, man, it ain't no loyalty in that shit. What part of loyalty says that I have to pay for you an attorney because you went out and caught a crime? I could still be your friend without giving you, but that's basically saying I got to give you money to be your friend, bro. You went out and caught a crime. I got kids to feed. I got shit to do. I ain't got to give you my money. And real niggas understand that. That's why you never really see real niggas on the internet crying about nobody paying. It's always the niggas who snitching and got snitch mentalities and snitch tendencies that cry about that type of shit. It's always them type of dudes. What the hell are you crying? And you so jealous. You so jealous of Big U that you actually, oh yeah, he got a paid attorney. And see these dudes, you monitoring this man so hard. But then you expect people to believe that you're not involved in the case, or that you're not participating in the case, or that you're not in some way providing information on the case, when all you talk about is, if that's all you got to talk about when you come to the internet, then obviously that's all you focusing on when you off the internet. You spend your every second of every day gathering up as much information about Big U as you can so you can come to the internet with it. Like the shit, and you kind of slow. So, you know, the shit that you take 2 or 3 days to do, I could do in 30 minutes or an hour. But you spend all day, every day gathering up information to come. These niggas so dry. Oh yeah, Big U. Look, you see in the paperwork, they said he got a court-appointed attorney. Most niggas who go to the feds get court-appointed attorneys just to save money, bro. Like, if we being honest, you should know this. You done dealt with the feds before, nigga. You know this. And then you got to look at the flip side. You get a nigga like Pooh Shiesty, right? Pooh Shiesty got this expensive-ass law team working for him. And the best defense that they can come up with is, oh, he went to Staples to print out some music lyrics. Oh, he went to Staples to print out. Big 30 got this expensive ass lawyer, and the best defense that they can come up with is, oh, he was there, but he didn't participate in no robbery. He just followed instructions. He just did what he was asked to do. He just stood by the door. Ain't nobody even deny being there. That's the crazy thing. Like, if you not gonna flat out deny being there, just don't say nothing. And that's my take on it, man. Them attorneys shouldn't even try for a bind. If trying for a bind means that you have to admit being on the scene, and by Big 30 saying he just took instructions, that means Shiesty told him to do it. So now you not only confirming his presence, but you also giving up some details of what he said. This shit is not that hard, bro. But y'all make it hard because niggas be trying to do all this extracurricular hating. That man paying all that money for them lawyers, and they ass is just throwing each other under the bus. So Big U being smart, doing what any smart individual in his situation would do, is definitely something that I would do, and it's documented. You can go look it up. I would do this exact same thing. I would take all of this opportunity to go into the law library myself and study my case as much as possible, going pro se or with standby counsel, so that I can have knowledge of what's going on. But you can literally navigate his way through this case, because once you go pro se, or you got standby counsel, appointed counsel, you can get extra access to the law library. Now, when instead of having to pay the attorney, oh man, look, I need to go research my own shit. Y'all got to give me these certain amount of hours because I'm representing myself. You know what I'm saying? And you get access to the evidence that they got against you. And it gives you an opportunity to better weigh your options with regard to, whether or not you're going to take a plea and what you facing. These niggas don't know how to fight cases. And the reason they don't know how to fight cases is because they never do. They just go in there and tell. That's it. So I get it. I see all the propaganda too. Trust me. And I'm not afraid to say these niggas' names, but I just have come to the conclusion that I give these niggas more light by even saying their name. And you know what I mean? Like, it's not making them bigger, but it's making them relevant. And it's giving them an opportunity to go back and forth with me, engage for content. And that ain't even what I'm on. I'm here to bring y'all the facts, the real breakdowns, and let y'all know what's really up, what the system trying to do to this man. These dudes, they got an agenda. These dudes jealous of Big U because they name never reached the status that his reached. These dudes jealous of Big U because of the support and the love that he get, despite the fact that they running around here spreading all this propaganda on him. These niggas really just jealous because they want to be in his position. They would love to be in that position. They would love to be. Of course, niggas gonna say they don't want to now because they ain't had the opportunity to. But if these niggas could have got out and been running around, having the type of time he was having, then they would have been doing it. But they can't. And niggas say, oh, well, I don't want to do that. And obviously, you don't want to be a snitch either, or you wouldn't be running to the feds complaining about somebody exposing you for snitching. It's that simple. Yeah, man, don't get confused. Don't get misguided by the hate. Don't let it distract you from what's really going on. They trying to deflect. Oh, he ain't got a paid attorney. Man, that man trying to get access to his own shit. Once he get access to his paperwork and his case, and he see what's going on and what they really got against him and how he want to fight it, I'm sure if he want to, he could bring in an attorney to do that. But me personally, I wouldn't do it. I would spend as much of my time fighting my case and learning my case as possible. So no matter what happens, I know my case in and out. And if other laws come up or other information come up that I wasn't privy to at the moment, I still have all of this knowledge and know how to apply. Knowledge without application is ignorance. You know what I mean? If you know it and you don't apply, you ignorant. With that said, I'm going to wrap this up. I'm out.